Chairman. This was touched on a little bit.
Yes, Senator.
In our construct, we have a system of two sovereigns, state and federal, in both our governments and in our courts. Which court is ultimately the most responsible for protecting individual rights?
Well, I think that in terms of constitutional protections, one of the things that I think is really important about the New York Constitution and the way the New York Court of Appeals has interpreted it is that where there are protections that have an analog in the federal Constitution, the New York Court of Appeals has said that it will evaluate for itself what the scope of those protections should be. And so in those circumstances, the federal Constitution would act, I think it's fair to say, as a floor, and the court will decide whether or not some more robust protection is appropriate.
So that would be specifically for protection of individual liberties?
Absolutely. So, for example, there is a seminal case from the Court of Appeals called People versus PJ Video. And it's a case in which the Court of Appeals said the protections available to individuals under our freedom of speech clause is more substantial than the protections available under the First Amendment of the federal Constitution. And I think that that is very much an individual liberty.
So when you're talking, and you mentioned Justice Brandeis earlier in
Yes.
the laboratories of democracy, our U.S. Constitution limits federal power.
Yes.
But the Federal Bill of Rights outlines very clearly those individual liberties, that Bill of Rights. Should states be taking direction from federal courts in the United States Constitution when it comes to issues of individual liberties, or should they be their own laboratories of democracy when it comes to individual liberties?
Well, I guess I'd say a few things in response to that question. I think certainly states can't go below whatever the federal Constitution requires.
What do you mean by below?
So, for example, a state court could not say a statute is constitutional under the state freedom of speech clause, even though it violates the First Amendment of the federal Constitution. So it can't somehow set a level that goes below the federal protection, because I think at that point the federal protection would kick in. That's what I mean by that. But beyond that, I think that a number of states, and New York is one of the leaders, have decided that it is appropriate to look at constitutional rights that have a federal analog. Not all of them do, but many of them do, to look first at what the federal courts have said, to weigh that seriously, and then to decide whether some additional protection for that individual right is warranted under the state constitution and the values that it rests on.
Great. And I'm sure you're aware, on June 23rd, 2022, the U.S. Supreme Court in New York State Rifle and Pistol Association versus Bruin struck down a provision in New York State's law that requires an applicant for a concealed carry firearm license to demonstrate what they call proper cause for the issuance of a permit. Are you familiar with that case?
I am familiar with Bruin, yes, Senator.
So New York State was found in violation of Second Amendment rights, essentially, infringing on the Second Amendment there. So would you agree with the Bruin decision then?
Senator, I would certainly follow the Bruin decision if I were confirmed to the court, as I would be required to follow any decision of the U.S. Supreme Court that was relevant to a question before the court.
And then this body and the governor of New York actually called an extraordinary session in reaction to the United States Supreme Court's decision here, putting in what they call the CCIA, Concealed Carry Improvement Act, in July of 2022, adding things like good moral character, giving discretion there, and disclosure of social media accounts, which probably looks to the First Amendment. Should New York continue to operate this laboratory of democracy or a laboratory of violating constitutional rights? Or at some point, does the U.S. Constitution and respect for decisions of the United States Supreme Court come into play? And what's your view on that?
Well, my understanding, Senator, is that a challenge to that statute is pending before the Second Circuit Federal Court of Appeals right now. And so I think the federal courts will answer that question. That case may go up to the U.S. Supreme Court eventually, and I think that that's what will resolve that issue.
And I noticed, you know, they actually printed, when I got to the Senate, I'm a freshman here in the Senate, they printed out these nice New York State constitutions. They have my name on there, and I can hand them out to constituents, but they're not as handy to hand out as the
They're
United
a little
States
longer. Yes,
Constitution.
Senator.
It doesn't fit in my pocket the way
Yes.
that those U.S. constitutions, which are, you know, state constitutions are pretty thick, some say robust. Should states enshrine the Federal Bill of Rights in their constitution to alleviate some of these issues?
I also have a couple copies of the federal constitution, and you're right, they are pocket-sized, and the state constitution does not come close to that. You know, a number of the amendments in the Federal Bill of Rights, I think, are encompassed in the state constitution as it is right now. And I think that beyond that, you know, one of the virtues, I think, of our system of federalism and the fact that we have both federal and state sovereigns is that states, through their own process for amending their constitutions, can make those choices themselves. But I do think there's a fair amount of overlap right now between the Federal Bill of Rights and the New York Constitution.
So, and this was a while back, 20 years ago, in fact. In 2003, you advanced a legal theory that gun manufacturers, and you actually mentioned this
Yes.
in your opening remark, that gun manufacturers should be liable for criminal conduct of people using handguns. As Solicitor General, you argued that New York County Supreme Court erred in dismissing the action brought by the Attorney General's office, which alleged that the defendant handgun manufacturers, wholesalers, and retailers had created, contributed to, and maintained public nuisance. Why did the appellate division of the First Department tell you that you're wrong in that argument?
Well, I believe the appellate division said that there was not room for that cause of action to proceed and, you know, dispense with it.
And while serving as Solicitor General, you authored and submitted an amicus brief, the case of New York City versus Beretta. Do you remember this one?
Yes.
Did you author that amicus?
You know, that was a very long time ago. My guess is that I would have certainly reviewed it. Whether I authored it or not in the first instance, I really couldn't tell you.
So this case dealt, at least in part, with the constitutionality of the Federal Protection of Lawful Commerce in Arms Act. You worked with then AG Elliot Spitzer
Yes.
at the time on this, and challenging Congress, actually, who had put this bill in place in order to protect firearms manufacturers. Why did you lose that case?
Well, again, I think the court concluded that the federal statute was proper and that it precluded the cause of action that the Attorney General was looking to bring.
Do you, and this is just my lack of familiarity, when you have the job of Solicitor General in the state of New York, do you swear an oath of office?
Yes, I do.
So as Solicitor General, talk to me a little bit about that conflict, because when you swear an oath of office, you're swearing to uphold not only the New York State Constitution, but the United States Constitution. So do you think of that when you write an amicus brief like this that's saying, no, New York State is not violating the United States Constitution, and then in fact the United States court says, no, you are violating the United States Constitution?
Well, I think, Senator, there are a number of cases brought by all sorts of litigants in which a court at the end of the day concludes that the Constitution means X and not Y. But I certainly don't think that suggests that the lawyers who are advocating for a position in that case are themselves violating the Constitution. It's the role of the courts, I think, to make a judgment about where that line in fact lies. And until they make that decision, you know, we don't know where the line is.
What are your personal feelings on the Second Amendment?
Senator, I would, as I said, follow Bruin if I were confirmed. And I think my personal feelings on that question, in addition to any other question, are really beside the point if I were to be sitting as a judge. And I would really, as I said, be very conscious about setting aside personal views on any issues, which we all certainly have, if I were hearing a case that involved any question.
Should New York State include a version of the United States Second Amendment in our own Constitution?
Well, Senator, I would leave that up to this body that would have to deal with that in the first instance, and then the people who would vote on that in the constitutional amendment process.
Thanks.